This is Werner Sabo. I'm a construction attorney and architect in Chicago. I'm also an arbitrator and mediator. In these videos, I discuss arbitration and mediation topics. In my other videos, I've often talked about the idea that an arbitration award is virtually impossible to overturn. Now, it's mostly true, but there are some ways and some exceptions to that rule. So, for instance, the AAA, the American Arbitration Association, their rules provide for a correction of an award. And the circumstances for that are if the award on its face has clerical, typographical, technical, or computational errors. So you get your award, and you take a look at it, and look at the names. Who is the award against? Sometimes the award may misname a party. Sometimes the numbers simply don't add up. So that's an error that could happen in a complicated construction case. So for instance, there may be a number of discrete claims, and the arbitrator lays out what each of those claims are and what the award is for each claim. So as a simple example, let's say there's two claims. The roof leaks, arbitrator awards $100,000 for that. The windows leak, arbitrator awards $100,000 for that. But the bottom line on the award is an award of $400,000. So the numbers simply don't add up. So that's a computational error. And what you do is you bring that to the attention of the association, or however your rules read. And if you do that within the proper amount of time that's allowed, the arbitrator would correct that award. And the same thing applies to typographical error, some kind of technical error, or that sort of thing. It's got to be evident from the face of the award, and the arbitrator is not allowed to change the merits of the award. The guts of the award can't be touched once the arbitrator has issued an award, even if there's a simple mistake in it. Now, let's say you're still unhappy with the award. What do? You could go running into court. And there is a procedure in court. The Federal Arbitration Act has a procedure, and most of the states have a very similar procedure with similar time limits. So let's talk about the FAA, Federal Arbitration Act. There is a procedure to confirm or vacate an award. So if you get an award in your favor, the other party doesn't pay, you're probably going to have to go into court to confirm the award and get a judgment, and that then allows you to proceed with collection against that party. Now, the other party at that point could, in that same proceeding, move to vacate the award. And there are certain grounds under the FAA for vacating an award. So the first ground is corruption, fraud, or undue means. And what that means is that there is something really bad happening. So the arbitrator was corrupt. Maybe he got a bribe. Maybe some kind of fraud occurred, and you find out about it, and you go into court to overturn that award based on that. That is incredibly rare and probably not going to happen. The next ground is evident partiality or corruption. A similar ground, and basically it's some kind of bias. And again, that's very difficult to show, and you have to show, if you're the party that's moving to vacate that award, you have to show that that award, and whether it's by one arbitrator or a panel of 3 arbitrators, that there was partiality on the part of the arbitrator or the panel. And how do you do that? Well, the record shows that there were all these rulings against me. Maybe you've got a record by a court reporter, and that's probably not going to cut it. It's just because the arbitrators ruled against you isn't going to cut it. You're going to need a lot more than that. You're going to need something behind the award, something that shows that there is some real partiality or corruption. I'm not saying it can't happen, but if you have quality arbitrators, it's really unlikely. It may happen in a situation where you're getting a first-time arbitrator that, not through one of the recognized organizations. There's a possibility that may happen. The third reason is arbitrator misconduct, and that can be by refusing to postpone hearings upon sufficient cause, refusing to hear pertinent and material evidence, or other misbehavior. So what that means is you have a hearing coming up, and maybe some judge has scheduled a court motion on that same day, and you want to go to that motion, so you ask to postpone the hearing. Probably not enough reason to overturn the award. Now, most arbitrators, if you get on a conference call on a sort of an emergency basis, I've got this or that happening, most arbitrators are going to be very reasonable the first time this happens. And, everybody gets a break at least one time, and it's sort of my rule. Now, if it happens again, then that becomes a real problem. One of the reasons that this is a problem at all is that the parties schedule the hearings well in advance, probably several weeks or months out. And if one of the attorneys then has something where they can't attend the hearing and it has to be postponed, that may delay things by weeks or possibly months, depending on the size of the case and the number of witnesses and that sort of thing. So you don't, as the arbitrator, you don't want to postpone hearings because it's going to be a real inconvenience to everybody else. But if it's a real serious matter, if the arbitrator got, or the party or the attorney got really sick, maybe something like that. But if the attorney there's a backup attorney, which in big cases you're going to have probably 2 or 3 attorneys working on the case. Why can't the other attorney handle the case at least on that one day? But if it's something serious and a judge decides that the refusal to postpone the hearing should not have been granted, and it's obvious from everything else, there's a possibility you may get some sympathy from that judge. Refusing to hear pertinent and material evidence, probably not going to get you a court to vacate that award. What happens is usually there's tons of documents that go into evidence, and what most arbitrators today will do is they will allow everything in. So one party comes in with 500 emails and 1,000 documents. Okay, it's all in. No foundation needed, it's in. And then during the hearing, you talk about the important documents. And it's going to be pretty apparent whether these documents are legitimate. If there's an issue with them, there may be an objection to a particular document that has some merit. So the arbitrators are going to focus on those documents that are discussed at the hearing and but there's probably a lot of other documents that are let in, but not really given any sort of weight at all. So refusal to hear evidence or let documents in, if you have a competent arbitrator, that's not going to go anywhere. Witnesses, if you have 10 witnesses that basically all say the same thing, at some point the arbitrator is going to say, hey, wait a minute, I'm hearing this over and over. That's it. I don't want to hear this same evidence again. That's not going to be a reasonable ground to overturn that award. And other misbehavior, that could be anything. But again, the misconduct or the problem has to be either apparent on the face of the award, or there has to be a good record that allows for an appeal of that award. And finally, the other ground is that the arbitrator exceeded her powers. So the arbitrator is given certain powers, generally by the contract. And if the arbitrator exceeded her powers or imperfectly executed them so that a final award was not made, that is a legitimate reason to overturn an award. And so, for instance, the agreement says the arbitrator may not award punitive damages. It's not uncommon to see that in sophisticated contracts. You get the award, and there it is, $10 million in punitive damages. Whoa, that would be, you'd have a good shot at overturning that, or at the very least, carving that out of the award by the court. You're not going to be able to do that in AAA. You'd have to go up into court, but I think you'd have a good shot at that, unless there is some kind of waiver shown that both parties agreed to waive that provision of the contract. So those are factual issues that the judge would hear and determine if the award is, if the arbitrator really exceeded her powers. The other provision there is that if a final award is not made, or if an award is made that really isn't final, you have to carefully read the award. And sometimes there's interim awards, and there's various things that happen where a judge might conclude that, hey, wait a minute, this award is not a final award. And if it's, first of all, if it's not a final award, it may not even be subject to a motion to vacate or confirm. It may be nothing, but it's something you've got to look at to determine, did this arbitrator properly issue a final award? Because that's really what you need at the end of the game here. So again, if you've got competent arbitrators that are drawing up this award, it's probably pretty unlikely that you're going to have that situation. But there are arbitrators that are not attorneys. There are arbitrators maybe that haven't done many arbitrations, and it may be more likely that you're going to have an award that's problematical. So under the FAA, the federal rules, you can also ask that court to correct or modify the award. And it's basically, it's evident miscalculation, or the award is on a matter not submitted. So if the award is about the windows in the main building, or if the matter is about the windows in the main building, and suddenly the award talks about the sauna in the guest house, that's not even part of the whole matter. Again, the judge may be able to modify the award based on something like that. Very rare, and it kind of overlaps the modification or correction provision in the AAA rules. Another situation that sometimes comes up has to do with attorney's fees. You may have a contract that says the arbitrator can't award attorney's fees, or just, no attorney's fees in the contract. What happens sometimes is the attorneys are zealous, and when they originally file their claim and their counterclaim and so forth, a lot of attorneys ask for attorney's fees. And there's a good argument to be made that if both sides ask for attorney's fees, that modifies any provision in the contract that says no attorney's fees. So you've got to be careful of that. Look at your contract, look at the provisions about attorney's fees and decide if you really want to have a dispute over attorney's fees. And if so, you can waive that. And if the other side does it too, you've probably got a good waiver. So think about that. And that's something that is a strategic decision, but it's certainly something that I've seen happen on a regular basis. And also on that, sometimes it's a very sort of innocuous mistake by the attorneys, because some of the forms will ask you, what is basic information about the claim, the amount of the claim, and sometimes there's a checkbox that says, are you asking for attorney's fees? That's checked, boom, there you are. And if the other side checks that same checkbox, you've possibly waived a provision of your contract. So what about records of hearings? If you're taking basically an appeal from the award, you're going to the federal court in the case of the FAA or the local court, that's an appeal, and the judge looking at this is going to need to base whatever decision he makes on a record, on something. And it's got to be more than just the award itself. In 99 cases out of 100, unless there's something very evident on the face of the award. That's your miscalculation, the misnomer issues that are pretty simple. But if it really is an attack on the award based on bias or partiality, refusal to hear evidence, that kind of stuff, you're going to need a record to show that happened. So, which means a court reporter. If you don't have that court reporter, it's probably pretty much impossible to get it overturned, because the court's just going to say, we don't know what happened, we weren't there, and there's no good record. So even if you're right, without that record, you're not getting anywhere. Now again, because the odds of actually getting an award overturned are so slim that an investment in a court reporter probably isn't a good investment if the only reason is to have a potential for an appeal down the road. Now, there are other reasons for having court reporters present, and that's especially on a larger case, to help the attorneys prepare for the next day of hearings, which the hearings are sometimes broken up because there's so many days of hearings. And it's something, it's a tool for attorneys to help them present their case. So if that's the reason for having court reporters, then that's a good reason to do it. But simply to do it because you might have an appeal down the road, that's a very expensive outlay of money and not worth the cost. If I'm the arbitrator and there's a court reporter, of course I'm going to want a copy of the transcripts that are prepared. It does help me on larger cases to prepare an award, but again, I leave that up to the parties whether they want to do that or not. It's not required, and it's going to be up to the attorneys. So the bottom line is very, very difficult to overturn an arbitration award. If you have competent arbitrators, it's even more difficult. And the only issues I see on a somewhat regular basis, I would say it's still very rare, is that somebody's made a mistake. Maybe one of the parties is misnamed. Maybe it's not an LLC, it's you know, it's a PC or something like that, and so it's misnamed in the body of it. But generally, you know, my awards are proofread by the American Arbitration Association, which is where I do most of my arbitrations, and they'll point out typos and things like that. So that makes it less likely that I make a simple mistake like that. So the awards, when you look at arbitration, you have to assume that that award that you're going to get is going to be final and you're not going to have a chance to overturn it. If there is something wrong and it's serious, yes, take a look at it, but don't count on it.